Hello there, Attorney Andrew Bethel. In addition to being the time we look back at how we did the year prior, New Year's is also where we look forward and focus our goals on what we want to accomplish in the future. New Year's also brings new changes, and everyone's favorite topic, tax law and estate planning, is no different. As you look forward to the new year and chart your goals, keep in mind these tax changes so you can maximize your 2023. But first, please be sure to like the video, subscribe, and ring the bell. Also leave a comment below if you have any questions or have a topic you wish for us to cover. But as always, thank you very much for watching and Happy New Year! First up are estate taxes. This is a tax on the value of your estate when it reaches over a certain amount after you pass away. That's why people call it a death tax. Last year, it was about $12.6 million. This year, it's a hair shy of 13. $12.92 million to be exact. This means that so long as your estate is below that number, your estate won't owe any taxes federally. There are 13 states that collect an estate tax at different levels, but unless you live in one of those states, then so long as your estate is under the exemption level, no taxes. This number will go up again in 2024 and 2025. However, if Congress fails to pass any legislation for 26 and beyond, the exemption level will go back down for 2026 to probably around 6 million or so. Speaking of death and taxes, the federal government does not collect an inheritance tax, while 6 states do collect one. Iowa, Kentucky, Maryland, double dipping with an estate tax, Nebraska, New Jersey, and Pennsylvania. If you don't live in one of those states, then great news, no inheritance tax for you or your heirs. If you do, though, speak to an attorney in your state to see if there's a method to minimize it. However, what if you wanted to simply gift money to someone to avoid estate and inheritance taxes? Well, the government's thought of that since they want their tax dollars, so there is such a thing as a gift tax. It's a tax on the giver based on how much they give away and not the recipient. In 2023, you'll be able to give away up to $17,000 per person without having to pay a tax. That means grandma can give that favorite grandson a few more dollars in the birthday card without having to pay a tax. Going further, this is only a tax on the giver per recipient, meaning I can give 4 people money, and so long as I didn't give more than $17,000 to any one of them, the government doesn't care. The second I give someone $17,001, then I have to pay a tax on the overage, 40% of that extra $1. However, there is a neat little thing called a lifetime gift tax exclusion. That is, I can give away money and assets up to that exclusion limit during my lifetime, apply it towards that exclusion limit number, and not pay a gift tax unless I were to exceed it. It does entail me telling the IRS I am applying the gift towards my lifetime exclusion, but so long as I do so, I can move a lot of money and still not pay a tax because that exclusion limit is equal to the federal estate tax exemption, which, if you remember, is now $12.92 million. Next is something that is wholly state specific, and that's the small estate threshold. It's the maximum value an estate can be before it is required to go through probate court and get a judge's approval before disbursement by law. In California, that threshold is any real property, regardless of the value, or a gross estate value of $184,500. It's going to stay at that level until 2025, where it will be adjusted based on inflation, so will likely jump up again. Real property will likely always be an automatic trigger in every state though, but the gross value will vary wildly based on the particular state. California will likely always have one of the highest thresholds at $184,500, so check your state's law when determining how much money to leave in your name alone, as opposed to having it in a trust or having a pay-on-death designation on an account. I know many eastern states have a lower threshold, and even Texas wants court approval for something as low as $5,000, so look out. Now let's discuss your home. While the rules for homestead exemptions vary by state, here in California, we recently had an increase in the exemption limit thanks to California Assembly Bill 1885 back in 2020. It brought it up to between $300,000 and $600,000. The actual amount will equal the prior year's median home sale price amount if it's within that range. So to put it simply, the minimum exemption is $300,000 and the maximum exemption is $600,000. But your particular exemption limit will not be the average, but the median home sale price for the prior year for your county. Additionally, these figures will be tied to inflation and adjusted annually. Now, regarding your estate plan, or potentially the lack thereof, according to a survey conducted by the senior living referral service Caring.com, only about 33% of Americans have any sort of estate planning documents in place. This means about 67% of the population is leaving what happens to their estate up to whatever the laws in their state dictates. They're leaving what happens up to the government rather than having a say in the matter. Even though there are many benefits to estate planning, no matter the size of the estate, including saving thousands of dollars in legal fees, the overwhelming majority of Americans are still leaving things to others to figure out. Don't be part of the crowd, plan your estate, and do what's best for your family and heirs. Thank you very much for watching. If you enjoyed the video or found it useful, be sure to check out our other excellent videos here. But don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover in the comments below.